Hey, PSE 201. Good afternoon, good evening, good morning, wherever or whatever time you're consuming this piece of educational media. I am again Vic McInnes here in the lovely COVID-19 compound in Grovetown, Georgia. And today we're back to civil liberties, and we're going to transition a little bit into civil rights. I'm going to go ahead and tell you. Call up the slides that are on the documents page on Blackboard. It's Chapter 4, Part 2. The slides will be listed as Chapter 4, Part 2. For those of y'all who are taking Latin, that'll be Chapter IV, Part II. Okay? Let me review real quick where we're at and how we've gotten here. We will do a quick review. We'll jump into the lecture. We'll finish up on civil liberties today. Then we'll start talking about civil rights. And then the next lesson, which should be on Wednesday, we'll wrap up civil liberties and civil rights by talking about the civil rights movement, how a lot of that was accomplished. Hopefully what you're seeing at this point is what we talked about earlier. You know, we went through the Congress, which was Article 1. We went through the Executive, which was Article 2. We talked about the bureaucracy, which really isn't referred to in the Constitution. But is a long arm of the executive branch, and a lot of people say it's a branch on its own. And then we talked about Article 3, the judiciary branch. And so we sort of put all the players in place to have what is probably the most important discussion we're going to have in this course. And that's how we get and maintain our rights. Because if you remember, we started off this lecture originally months ago when we were in the classroom, it seems like, by stating that in many cases, a lot of people would like to define the history of the United States as a struggle for civil rights. It's a struggle between our personal freedoms versus the needs of the whole or the needs of the many. We talked about how our creators started out with the concept of natural law, and these were laws established by our creator. That allowed that we as humans were simply here to enact the Creator's will here on the physical world. We started off with, and then we went into that basic core concept of in the structural DNA of our country, that all men are created equal, and we know for a fact that just hasn't been the case. We started off talking about Korematsu versus the United States, where Fred Korematsu, along with 110,000 other Japanese immigrants or even natural-born American citizens who just happen to be of Japanese ancestry, were rounded up. There's no other way for it, and imprisoned, and we can talk about detainment centers and everything else. But their rights were suspended, so they were put in detention. They were put, in essence, they were imprisoned. Anything else to say in any other way is just an argument over words. And Korematsu refused to go. He was arrested. He appealed to the Supreme Court and gave us the second of our three most horrible Supreme Court decisions. And Justice Hugo Black, which is a great civil liberal judge, wrote what is considered the worst decision in the history of the U.S. Supreme Court, where he said Fred Korematsu was being detained not because he was of a Japanese race, but because he was of Japanese ancestry. And who knows what, we'll never know. Justice Black has passed on. We'll never know what he was thinking when he wrote that. He did not talk about it, but again, whenever you see his biography, it starts off with a line, in the first sentence, a great liberal jurist, but wrote the decision in Korematsu. Then we talked about the enumerated rights. Those are those 5 rights that are listed specifically in the Constitution. Remember, we said that the Constitution did not in any way attempt to identify all the rights we as people should have. There were 5 enumerated rights, no religious test, for office, and that was it. And one of them was a Bill of Attainder. We talked about the U.S. v. Brown. Archie Brown was an American communist. And there's the title of a sitcom for you, Archie Brown, American communist. But anyway, Archie Brown was an American communist who was denied a job within his union because there was a law that said just communists couldn't do it. And they went to the Supreme Court, and the Supreme Court said, yeah, that's a bill of attainder. That's something done specifically to target a small group of people or an individual without the benefit of a trial. So that's what a bill of attainder is. And again, that's one of the 5 enumerated rights listed in the actual Constitution itself. Then we talked a little bit about the Bill of Rights that assure our basic freedoms, those 10 Bills of Rights that limit the power of the federal government. And then immediately we talked about the Alien and Sedition Acts of 1796, which were passed by people who had actually written the Constitution. But we were in, again, the quasi-guerre, the quasi-war with France. President Adams wanted to shut down all immigration because he thought immigrants were hostile to him personally. He was a Federalist, and he felt that the immigrants were not Federalists, so he tried to shut down immigration. He also tried to shut down all criticism of the government. 2,100 people were arrested, including, he went so far as to arrest a member of the U.S. House of Representatives. That backfired on him. He was not even in contention for in the presidential race of 1800. Remember, it came down to Jefferson and Burr. Went to the House of Representatives. Record number of votes in the House of Representatives. 35 ballots in the House of Representatives. Jefferson became president. He did not have the wherewithal at that time because, remember, this is before Marbury v. Madison, and he barely got elected president. So he couldn't directly overrule the Alien and Sedition Act. So what he did is he got states to nullify it. Now, again, we see that as, hey, maybe that was an effective tool, but it set the course for nullification, which ultimately led to the Civil War. We talked about the Espionage Acts of the early 20th century. And we talked about Schenck versus the United States. Again, Schenck was trying to mail out 15,000 flyers to get young men not to sign up for the draft. He was arrested. The Supreme Court upheld that, but said that as long as the speech presents a clear and present danger to the public good, speech could be restricted. And again, we all know that Justice Holmes's example was yelling fire in a crowded firehouse. Excuse me. That presents a clear and present danger to the people. Fire in a crowded theater. That presents clear and present danger to causing the inciting panic and hurting people. We then went and talked about, one of the last things we talked about was Brandenburg v. Ohio. Remember Brandenburg, and this was a case from the early 60s. Brandenburg, in the other case that was associated with this, was a guy named Richard Hanna. Horrible people. Horrible people. Again, you'll remember that photograph from the Associated Press with Chambliss wearing his Ku Klux Klan robes and Hanna in his Nazi uniform. But the ACLU picked up this case, and we're going to talk next time about the ACLU picking up really unpopular cases in order to defend people's rights. But Justice Douglas said that in ruling on Brandenburg and throwing out the conviction in Ohio of Brandenburg, Justice Douglas said there had to be a two-pronged test. Prohibiting speech must be done with the intent of inciting lawless action. And that second part of the test, it has to have a likelihood of producing a lawless action. And Douglas said that Brandenburg, the Klan, did not have the ability to incite lawless action at that point in time, so it wasn't really an issue, so they threw it out. Now, the question you may be asking is, you know what, I'm going to hold off on that. That may be a discussion question that I give you after our next lecture. Okay, so now let's pop over to the slides. We're going to start with a slide that says First Amendment, Chapter 4, Part 2. And what you're going to hear today and what you should be picking up is that there's a lot of, this is good. The hard part about doing this lecture is that it oftentimes turns into a laundry list of court cases. What I'm going to try to do with each instance is to sort of give you a bigger sort of view of how all this sort of runs together. So the first thing we're going to do, and I'll be trying to define trends for you. So the first thing we're going to do is take a look at our first 5 amendments in the Bill of Rights. The first 5 amendments to the Constitution. And we're doing the first 5 not because, well, first of all, if I did all 10 of the Bill of Rights, it would just get tedious. But this is a good example of showing you where the founders of the Republic, the Founding Fathers who wrote the Constitution, sort of gave us a blueprint for what our freedom should be, and then we immediately start restricting it. We saw, again, through the Alien and Sedition Acts, John Adams, who wrote huge parts of the Constitution of the United States, wound up trying to limit the First Amendment. Okay? So we've already seen in Schenck and Chambliss that there is a limit to free speech. There have been on multiple occasions in the past where there was a limit to free speech, and sometimes the courts have gone along with it, sometimes the courts have stepped away from it. But here's 3 specific examples of where freedom of, again, remember the freedom of the First Amendment gives you speech, press, religion, and the right to assembly. Okay? Well, in Tinker v. Des Moines, and this is something that you guys should be really interested in Tinker v. Des Moines School District in 1969, the restriction of free speech was considered permissible in this case when it materially and substantially interferes with the requirements of appropriate discipline in the operation of a school. Okay? So, yeah. Tinker v. Des Moines School District gives your principal the right when you come in wearing a Budweiser t-shirt to say, nah, you need to go home and change. You're not meeting our dress code. It gives school administrators a great deal of latitude to decide whether or not your First Amendment rights of free speech should be restricted. And the courts have said over and over again that within a school, your freedom of expression can be limited in order to maintain the purpose and safety of the school. In Reynolds v. the United States in 1878, again, this was a restriction on religious freedom. So George Reynolds was a secretary to Brigham Young, who was a founder of the Mormon Church. It was illegal in the United States, as it is now, to be married to more than one person at a time. Bigamy is where you're married to 2 people. Polygamy is when you're married to more than 2 people. Built into conservative, the Latter-day Saints Church, is that concept of polygamy. George Reynolds was married to 3 women. He went out to get arrested for being married to 3 women so that they could take the case to the U.S. Supreme Court. And that way they could prove that polygamy was a protected religious right. Well, when he got to the Supreme Court in 1878, things didn't quite go the way he wanted them to. The court relied very heavily on what's known as English common law. We talked about that, where there were certain legal practices in England that carried over to the United States. And in English common law, the law says you can only have one wife because that's how you determine who inherits your property. So it wasn't necessarily a religious issue for the justices. It became more of a economic and legal issue. But the key thing about Reynolds v. the United States, you could not use religious duty as a defense to a criminal indictment. In other words, you can't say, I robbed that bank because my faith tells me that loaning money for interest, which is called usury in the Bible, is illegal. It is against God's natural law. So in 1878, the justices struck that down. Now again, here's another one when we talk about freedom of the press. In Hazelwood School District versus Kohlmeyer, the public schools officials in the Hazelwood School District refused to allow a school newspaper to publish, and because it had negative information about the school district. It went to the United States Supreme Court, and what the court said was, school officials can censor school-sponsored newspapers because that newspaper is not an inherent organ of free speech. It is a forum. It is not a forum for public expression. It is part of the school's curriculum. Okay, that's a very fine line, but that's what they pay the justices for. So in 1988, they put a limit on the amount of free speech that you're going to get, you can have in school. So there's 3 key cases where our rights under the First Amendment are limited. Now, if you go to the next slide, but one of the other things the justices are asked to do is to define key issues. Now, it has been a standard concept and an acknowledged concept in our constitutional law that obscenity is not protected under the First Amendment. And this was first brought to the Supreme Court in sort of a modern era in Jacobellis v. Ohio. Nico Jacobellis ran an art theater in Cleveland. And he wanted to show a Louis Malle film called Les Amants, The Lovers. It's great. When you're much older, you guys can watch it. It would definitely be rated R. It is a French film. Louis Malle, great French director. Nico Jacobellis was arrested and fined $2,500 for violating the Cuyahoga County obscenity laws. So Jacobellis appealed. It went to the Ohio Supreme Court. It then wound up in the United States Supreme Court, where it was argued. And then Justice Potter Stewart came out with this sort of weird test for obscenity, where he said, when he wrote the majority opinion overturning the conviction, I shall not today attempt further to define the kinds of materials I understand to be embraced within that shorthand description, hardcore pornography, which was the Cuyahoga County obscenity statute, which said you can't show hardcore pornography. He said, I'm not going to attempt to define that shorthand description, hardcore pornography, and perhaps I could never succeed intelligibly in doing so. And this is the key phrase, but I know it when I see it, and the motion picture involved in this case is not that. So what Justice Potter Stewart is saying here is he wants to apply sort of a common sense test to obscenity laws. You know, what does constitute obscenity? What does not constitute obscenity? And Justice Stewart basically says here, listen, I know pornography, hardcore pornography, when I see it. I'm not going to tell you that hardcore pornography is protected, but what I am going to say is this film is not hardcore pornography. So it was sort of a gray area, but he opened up a whole avenue of free expression where he made it a stronger test for local governments who attempted to restrict freedom of expression. We pushed further into this in 1973, just a couple of years later, 9 years later, in Miller v. California. Marvin Miller sold adult books and movies by mail order, mailed out catalogs with some explicit, and this is Mr. Marvin Miller, obviously a classy character. Even in 1973, the guy's a bit of a, anyway. So he was arrested and under the California Code. What had happened was he mailed out a catalog to just random people with very explicit images in it. And an individual was sitting at his table with his mother. They opened up these catalogs, and there's all these explicit images. He called the police. They found Mr. Miller in violation of the California Penal Code. He was arrested. He was convicted. It went to the California Supreme Court. It then went to the U.S. Supreme Court. And Chief Justice Burger said that reinforced that while obscenity is not protected material, and if you want to find out, and he gave some examples that I am not, for good taste, I am not going to go into here. But what Chief Justice Burger said was, is it obscene to the average person? And he used the phrase, applying contemporary community standards. And that became the watchword. And he said, does the work depict in a patently offensive way sexual conduct specifically defined by the acceptable state law? And what that meant was, is it showing or depicting sexual activity in a way that clearly violates the state law? And does the work, and then taken as a whole, lack any serious literary, artistic, political, or scientific value? And so and this was a benchmark case. Because what Chief Justice Burger is saying here is it has to, number one, violate community standards. It, number two, has to be explicitly in violation of the law. And then it has to have no serious literary, artistic, political, or scientific value. So this sort of opens the door for a lot of what we call the adult entertainment industry. Now, and made it much harder for individual states and local municipalities and counties to prohibit that type of activity. Okay, so what we've seen, even with the most sacrosanct, okay, we now know the First Amendment, the freedom of press, the freedom of speech, the freedom of religion, the freedom to gather to redress grievances with the government. Even that, those freedoms can be modified, can be shaped, and in some instances just flat out restricted. And so you see this tension between the courts and the legislative branches. Now, when we get to the Second Amendment, and I'm not going to go real deep into the Second Amendment, you want to find this, go have a good time, but there was a decision, not in 208, this was in the District Court, District of Columbia versus Heller. So the Second Amendment people will say, and the gun rights people will say over and over again, read Heller, DCV Heller, as their big case that says that you should be able to own all guns. Well, the court did throw out a specific law within the District of Columbia that prohibited the carrying of a specific type of gun. But Justice Scalia even wrote in his opinion there, like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment or state analogs. The court's opinion should not be taken to cast doubt upon any long-standing prohibitions on the possession of firearms by felons and the mentally ill or law forbidding the carrying of firearms in sensitive places, and so on and so forth. So even though the Second Amendment says, the right to keep and bear arms should not be abridged, Justice Scalia, who was a very, very conservative justice, is even saying, hey, listen, the Second Amendment isn't a free-for-all. Okay? Like most rights, the Second Amendment is not unlimited. Okay? So we're going to, we'll talk about the Third Amendment real quick. And the Third Amendment says that the federal government can't quarter troops or make you, give rooms to troops. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So the Third Amendment is kind of unique. There's never been a Supreme Court case to deal with the Third Amendment. Not once. Nobody has ever had to sue the government because the Army put troops in their houses without their consent, okay, or without Congress passing a law. Now, at the beginning of World War II, a lot of land and property, especially in the Washington, D.C., suburban Maryland, Northern Virginia, Washington, D.C. area, the United States government seized a lot of property because we had to build up a federal government that could fight an industrial war. We talked about that earlier in the class. There were laws that allowed that. The one time it really came up, the Third Amendment really ever came up, was in Griswold v. Connecticut in 1965 when Justice William O. Douglas cited the Third Amendment in the Constitution as part of the Constitution's unstated right to privacy. And if we have some time before the course is over with, I will actually get into the right to privacy. It's one of our core central rights, and it doesn't actually appear anywhere in the Constitution. Talking about the Fourth Amendment, and that's your, now this is going to be one of the most, the Fourth along with the 14th Amendment are the ones that have been litigated the most. The Fourth Amendment protects you from illegal search and seizure. So, and that's basically where it comes down to, hey, listen, can they get into your car? Can they get into your house? Can law enforcement do that? Well, the first really case that came up was Weeks versus the United States in 1914. And Weeks had a key that was hidden outside his door of his apartment. The law enforcement guys found out about it. And so the question was, can a hidden key be used to expedite a warrantless search? Basically, what the police are saying here is, if he didn't want us to search his house, he shouldn't have left that key outside. And the Supreme Court said, no, that does not give you an excuse. Then there was New Jersey versus TLO. Now, TLO was, and this is a case that should interest you guys as well. TLO was a 14-year-old, the initials of a 14-year-old New Jersey student back in 1985. In this accident, she was somebody told on her. So they ratted her out to the snitched on her to the vice principal. Said she'd been smoking in the bathroom, and so the principal called her in. Vice principal called her in. She said she had not been doing it. He said, "Okay, dump out your purse." She refused. He then took her purse and dumped it out. At which point he found drug paraphernalia, marijuana, cigarettes, and a whole host of other things. She was arrested for possession of the marijuana, and the question that was key was, does the Fourth Amendment for protection of search and seizure extend to high school students? Well, the court came back and said, yes, it does, but there has to be a balance with the need of the safety in the schools. So, in drugs, the Supreme Court has held over and over again, boils down to, yes, that is a safety issue. So if you see the Aiken County Sheriff's bringing the dogs, sniff your lockers on a drug search in the schools, yeah, that's completely legal according to the United States Supreme Court. In Alabama v. White, there was a case where a woman, Ms. White, there was a single anonymous tip that said she was in possession of methamphetamines. The cops went out, rousted her, turned her car out, and found methamphetamines. She appealed based on the premise that there was only a single anonymous tip. And did a single anonymous tip provide sufficient probable cause for a search? The Supreme Court said, yeah, absolutely it does. Okay? And then finally, again, another one you guys should be aware of, the Vernonia School District versus Acton. This is from 1995. Is a random school drug test for athletes. Is that illegal under the Fourth Amendment, or does that, and also they brought this up under the Fifth Amendment, self-incrimination. Does the Fourth and Fifth Amendment prevent the school from randomly drug testing school athletes? And the court said they do not, because there's two things going on here. First of all, you do have rights, but there is the safety issue, number one, of having drugs in the schools, but also, the school board cast it as a safety issue. You do not want players on the football field. You do not want players on a basketball court. You do not want players in any sport that may be playing with impaired judgment due to the presence of a controlled substance such as drugs. Okay, so again, what we're seeing here is in these Fourth Amendment cases is a number of times when the courts have said, yeah, you do have Fourth Amendment protections, but they are not universal. Go to the next slide. And this one starts off with Olmstead v. the United States. And this is a very specific, and I'm bringing this up, because Olmstead v. the United States has to do with wiretapping. So in 1928, Olmstead was, phones were tapped for months. They were listening in on his phone lines. Olmstead was involved in any number of illegal activities. But they did not, the police did not try to get, the Federal Bureau of Investigation did not even bother to attempt to get a warrant to tap Mr. Olmstead's phones. And so the question came up, do police need a warrant to tap someone's phones? 4 months. And Chief Justice Taft wrote a majority opinion. Yes, this is former President Taft, who later became Chief Justice of the United States, wrote the majority opinion, and he said in the weirdest sort of way that just boggles your mind. He said there was no search, there was no seizure, the evidence was secured by the use of the sense of hearing and that only. So what Chief Justice Taft says is there is no need, you have no right to privacy when you're talking on the telephone at that point. And he was perfectly okay with that. It would be, 39 years before Katz versus the United States, which modified that. Katz was a gambler. He was a bookie. He ran a fairly large gambling operation. He was taking bets on college sports. And in 1967, he was using a tapped phone, payphone outside his building to run his illegal betting business. So the question, he was arrested based on those wiretaps. So the question came up as, what does a search mean? What constitutes a search? And so Justice Potter Stewart wrote the opinion, the Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not a subject of the Fourth Amendment protections. So what Justice Potter came up with what was called the test called a reasonable expectation of privacy. In other words, if you are expressing, if you have an area where you should have a basic expectation that people aren't going to be able to look for stuff without your permission, then if you want to search that place, you got to have a warrant. So if you want to be a 16-year-old driving around Aiken, 15, 16-year-old driving around Aiken County, South Carolina, and have a six-pack of buds sitting on your front seat, or a bag of buds sitting on your front seat, you have no reasonable expectation of privacy in that case, okay? But if you have that pot in your glove compartment, that's a reasonable expectation of privacy. They need probable cause or a search warrant to search that in your home. If you have illegal substances in your home, you have a reasonable expectation of privacy. And that includes communication. When you're talking on your cell phone, you have a reasonable expectation that no one is going to be listening in on that phone. Okay? And so that gives you the reasonable expectation of privacy. Okay. So, all right, everybody, deep breath. We're now going on to next line, Miranda v. Arizona. And the Miranda v. Arizona is one of the, Gideon v. Wainwright. This is one of the major criminal cases of the 1960s that completely changed the way we do law enforcement. Okay, on March 13th, 1963, Ernesto Miranda is arrested for kidnapping and rape. After his lineup, the police, he comes out, he has a lineup, and he's never told he has a right to a lawyer. He's never told he has a right not to talk. So after the lineup, he comes out and he says that, he asks, hey, how'd I do in the lineup? And the cops imply, they don't tell him explicitly, but they imply that he was picked as the kidnapper and the rapist. He was never offered a lawyer. He verbally confessed. He further offered a written confession. He appealed on that. At the trial, he tried to suppress his confession, saying that he was not advised of his rights. He did not know that the cops could not continue. He didn't continue to question him. He files a writ of certiorari in forma pauperis. We know what that means, and was granted, and his case went to the Supreme Court of the United States. So the core question is, are the police required? Now, we talked about in Gideon v. Wainwright, this is the follow-on case. We talked about in Gideon v. Wainwright, you have to, if you cannot afford a lawyer, the state has to provide you one. Additionally, you have a Fifth Amendment right to not incriminate yourself. Do the police have to tell you about that? So it went to the United States Supreme Court, and Chief Justice Warren was writing the decision for the court, stated, the person in custody must, prior to an interrogation, be clearly informed that he has a right to remain silent and that anything he says will be used against him in court. He must clearly be informed that he has a right to consult with a lawyer and to have a lawyer with him during interrogation, and that if he is indigent, a lawyer will be appointed to represent him. Okay? A lot of things to take apart there, but really everybody's seen TV where they bring out their, what is even called a Miranda card. So let's take that first phrase, a person in custody. These are called custodial interviews. If you are in custody, you are undergoing a custodial interview. And what that means is you don't have the right to leave anymore. You are being withheld. You are being restrained in custody. If a cop starts asking you questions and you ask, hey, listen, am I free to leave? Am I under arrest? Can I go? And they say, no, you can't until we get our questions answered. You are in a custodial interview because you are illegally in custody. And they have to inform you of your rights under Miranda v. Arizona. So first of all, there's that. Now, if you're standing on the side of the road, or if you're just having a chat with a police officer, and this has been gone to the Supreme Court on multiple occasions, and a cop just walks up to you and says, "Hey, can I talk to you for a second?" And you look over at him and say, "Yeah, I've got a body stuffed in the trunk of my car, but you haven't read me my rights yet, so you can't do anything about it." You're not in custody, so yeah, you're gonna go to jail for murder. Okay. This on Miranda v. Arizona does not deal with any time you talk to the police. It only deals with custodial interviews. Okay? Second of all, you have to be clearly informed that he has a right to remain silent. So according to the courts, over and over again, when a person in custody looks at you and says, "I have no desire to speak to you. I will not make any further statements." Okay? The courts have said at that point in time you're supposed to stop talking to them. Now, there is some flexibility there, but when it comes down to when you have a right to consult with a lawyer and to have that lawyer with you during interrogation, if you're in custody and you say, "I need a lawyer," the police have to stop questioning you. They cannot trick you. They cannot continue to try to get you to talk. And again, that's something that the TV shows get wrong all the time. When someone says, "I want to talk to a lawyer," the police cannot say, "Well, if you ask for a lawyer, you're going to look guilty." They cannot say that. Any confession they get from you after you say that will be thrown out. Okay? So Justice Warren very specifically sets all that up. Just to let you know, they overturned the conviction in Miranda v. Arizona. They didn't overturn it with prejudice. They said Miranda needed to be retried. He was retried. Without the confession, he was still found guilty. He went to prison. He served his time. He got out. Then relatively soon after he got out, he was stabbed to death in a bar fight. Interesting thing, when they were inventorying his possessions, cops call them Miranda cards. It's the card they have that has all the Miranda. He's had several Miranda cards on him that were used by police. But anyway, all right. So we're going to go to the next slide called exclusionary rules. Okay. While Miranda still stands, so Miranda v. Arizona was ruled in 1965 and still stands as the basis for your Fifth Amendment rights. Your Fourth Amendment rights that we talked about previously are constantly under review. For decades, through the Burger and the Warren courts, the court was very liberal, held the police agencies to a very high standards, but under Rehnquist, Chief Justice Rehnquist, and now under Chief Justice Roberts, they've been far more lenient in giving the police leeway in how they conduct their business. Okay, and the last one that was the last big, and what they call them is exclusionary rules, is if you don't, these are the rules that will result in evidence being excluded from a trial. And there's too many of them, and they change on almost seemingly a weekly basis. You know, the U.S. Supreme Court hasn't heard an exclusionary rule case since 2018, but the lower courts are hearing them constantly and constantly changing the law. The last one the Supreme Court heard was Utah versus Strieff. Edward J. Strieff, who you see here, upstanding Lincoln citizen, was spotted. The South Salt Lake, Utah Police Department had a suspected drug house under surveillance. They saw Mr. Strieff leave that suspected drug house. They subsequently stopped him, and everyone in this scenario, the police, the prosecutors, the state's attorney general, when it went to the Supreme Court, agreed that they did not have probable cause to make that stop. Mr. Strieff had done nothing illegal up to that point that the police had witnessed, so they had no reason to stop him other than the fact that he had been in a suspected, not a known drug house, but a suspected drug house. But everyone agrees that that stop did not meet the legal requirements for a search of his car. But they found out that he had outstanding traffic warrants, not drug warrants, traffic warrants. And so the South Salt Lake, Utah police searched the car. Prosecutors admitted the search was unlawful, but they said the warrant attenuated the connection to the search. So the warrant, even though the stop was unlawful, the warrant broke the connection between the stop and the search. So the prosecutors asked the court to look at these as two completely separate events. One event is we stop a guy and we find out, and that produced nothing, so it has no real relevance on the case. Second event, we found out this individual, Edward J. Sharif, has a warrant so we searched his car as is part of our process. The Utah Supreme Court disagreed and overturned the conviction. The state appealed. Justice Clarence Thomas wrote that the warrant did indeed break the bad faith chain and the search was valid. Now, the Rehnquist and the Roberts courts over the last 10 or 12 years have had 6 separate exclusionary rules cases come before the Supreme Court, and in every single instance, the more conservative Rehnquist and Roberts courts have sided with the police on every single instance. And that is a huge shift in the way the court works. We've talked about that before, about how the court changes. And we had those very liberal activist judges in the Berger and the Warren courts. Now we have very conservative activist judges with the Roberts and the Rehnquist courts. Okay? So let's click on to the next slide that says civil rights and civil liberties. So what we've been talking about up to this point is civil liberties. And this is from Lauren Ratliff-Santoro. She's a PhD that teaches at the University of Texas, Dallas. Civil liberties and civil rights are commonly used interchangeably, but they represent two fundamentally different principles. Civil liberties based on the Bill of Rights, the First Amendments to the U.S. Constitution, and the Due Process Clause of the 14th Amendment are political freedoms that protect individuals from government tyranny. Individual rights to speech, privacy, and to bearing arms are examples of civil liberties, and they are guaranteed to us as U.S. citizens. Civil rights, on the other hand, protect individuals from discrimination by the government and other individuals and originate from the Equal Protection Clause of the 14th Amendment. So think about it like this, because we're now about to start talking about civil rights. We're going to talk about the history of the civil rights movement to a certain extent. But civil liberties are the protections set up in the Constitution. Civil rights are how you execute those and the guarantees that you will be able to use your rights as a citizen in your day-to-day life. So civil rights, civil liberties written in the Constitution. Civil rights, how you take those civil liberties and the protections you have that say you will be allowed to use those civil liberties on a day-to-day basis. Let's go to the next slide, and start talking about civil rights. Clearly in the United States, you can pick any number of civil rights issues, but clearly the overriding civil rights issue in the United States deals with race. And we could pick any number of places of where to start. You could pick 1619, 400 years ago, last year, when the first enslaved person came to North America. Enslaved persons from Africa were brought to Virginia, and I do say enslaved persons because they were people. They were not slaves. They were not there because of some sort of DNA marker they had. They were people that were forcibly enslaved, so they were enslaved persons. So that happened in 1619. We could start there if we wanted to. We could start with 1793, the agricultural system in the South, where the primary crop was tobacco, and tobacco really sucks all the nutrients out of the soil, had pretty much died off. Slavery as an institution in the United States was very quickly becoming financially unfeasible. There was not enough money in growing tobacco to make maintaining an enslaved person's population worthwhile. Then Eli Whitney invents the cotton gin, and what had gone from cotton, which it went from a marginal product, became an incredibly profitable product. And farming cotton in the late 18th, early 19th century was a very manpower-intensive process. So the industrial farming complex in its early stages demands a huge cheap labor force, and that gave a rebirth to the institution of chattel slavery in the United States. We could start there. We started in 1820 when the Missouri Compromise, where politicians within the United States made a compromise that slaves would be admitted to the Union, one slave, one free state, to maintain the balance within the Senate, and we could go with that. We could start at 1830 when Nat Turner's revolt in Virginia, which is where an armed insurrection of enslaved people really terrified the South and created a whole new brand of repression that went across the South and terrified slave states and really brought about, the first instance where, these enslaved people could stand up for themselves. We could start that same year, which Nat Turner's revolt sort of gave an impetus to. The beginning of the abolitionist movement and the founding of the Underground Railroad. We could go to 1857, Scott v. Sanford. We've already talked about that, the Dred Scott decision, which sort of told everyone, and this is going to be important next lecture when we start talking about, how people adjust to the changing political structures. Scott v. Sanford, where abolitionists and begin to realize they're never going to get satisfaction from the courts, which leads to 1859, John Brown's raid on Harper's Ferry, where not just enslaved people, but white abolitionists begin to take up arms against the institution of slavery. John Brown raids a federal arsenal in what is now West Virginia, was then part of Virginia, in an attempt to seize weapons to give them to enslaved people so that to foment revolution. John Brown is captured and hung for it. And then, of course, in 1860, we have the beginning of the Civil War. So there's any number of places where we could jump into the civil rights stream and narrative and begin to talk about it. We are going to start by looking at those three amendments that were passed to the Constitution in quick order. After the Civil War, there was a flurry of constitutional amendments. Never happened before, never happened since. The 13th Amendment, which outlaws slavery and involuntary servitude, except as someone who has been duly convicted of a crime. Okay, and Congress was given the power to enforce the article by appropriate legislation. Okay, we have the 14th Amendment, which is the rights, guaranteed privileges, and immunities of citizenship, due process, and equal protection. Now, the 14th Amendment has 4 different sections. The one that everybody is interested in is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Man, and as you see there in the asterisk, the 14th Amendment is the single most litigated part of the United States Constitution. A lot to unpack in that, tons and tons of important stuff. First of all, where this has come up in the past is President Trump in the last couple of years has said that he doesn't believe if somebody is born in the United States, they should be guaranteed citizenship. And he said, I'm just going to do away with that. Well, President Trump has a tendency to show that he hasn't actually looked at the Constitution. And this is one of those cases. The President of the United States does not have the authority, at least now, to just say, I don't like that part of the Constitution, I'm going to ignore it. So in the first sentence here, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, okay, and of the state wherein they reside. So if you were born in the United States, you cannot be told that you are not a U.S. citizen. And there is nothing in the Constitution that says we can remove your citizenship. A lot of times people say, hey, listen, if you go join ISIS, you should not be a U.S. citizen. There is no provision, either in law or Constitution, that says if you were born here, we can take your citizenship away. If you were not a naturalized citizen, we can take your citizenship away. That doesn't exist in our Constitution. Okay, and then it says further, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. I want you to remember that phrase, because when we start talking about poll taxes and literacy tests and Jim Crow laws and next lecture, that is going to be massively important. And also, no, nor shall any state deprive any person of life, liberty, or property without the due process of law. Okay? So the 14th Amendment Section 1 is incredibly important. Okay? And also that last part, to deny any person within its jurisdiction the equal protection of the laws. Again, can the states pass laws that specifically discriminate and prohibit people of a particular, ethnicity, any number of things, the protection of the laws? And the 14th Amendment clearly states they cannot. So the 15th Amendment says the right of a citizen to vote. Section 1, the right of citizens of the United States, which we defined in the 14th Amendment, to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have the power to enforce this article by appropriate legislation. Now, the 13th, 14th, and 15th Amendments are always usually looked at as a group because they were passed immediately after the Civil War as part of the continuation of President Lincoln's and the Union's and the Republican Party's attempt to abolish the institution of slavery and all the remnants thereof. And these three worked incredibly well in the South through Reconstruction, but then when Reconstruction ends, and the Union Army, the Federal Army at that point, stops occupying, being an army of occupation in the former Southern states, protections under the 13th, 14th Amendment will basically disappear until the Civil Rights Movement, which really begins in the 1950s. Okay? So I want to have a conversation real quick that's kind of tougher, and I'm not going to read the details of this. I strongly recommend that you read it. Ta-Nehisi Coates is one of the great writers that's currently publishing today. He publishes a lot in magazines. He's written a couple of really thought-provoking books. Ta-Nehisi Coates has directly confronted what a lot of people refer to as the demographic bomb. There's a lot of things, a lot of people out there that say, as we progress within the next 10 years, the majority of people in the United States aren't going to be what we currently call white. They're not going to be Caucasians of Northern European ancestry. Up to this point, right now in American history, we define white, if you accept white as being the ethnicity or the ethnic group that holds the predominant political power, then you have to look at white as being predominantly people of Northern European descent. But that isn't, but Ta-Nehisi Coates makes that white and race is a social construct. In the second paragraph, he said, when the liberal says race is a social construct, he is being not being a salted adult. He is speaking of historical truth. So at the beginning, in the Revolutionary War, when we defined our rights, the concept of who had rights were based on being of Northern European descent, but specifically, generally it was considered English, it was considered French, it was considered Dutch, and it was considered to a lesser extent German. Irish, not part of that group. Scottish, not part of that group. Spanish, not part of that. People from Spain, as opposed to Hispanic. People who are of Spanish ancestry, not part of that group. Jews, not part of that group. So white in that construct was very limited. So what happens is over time, there's mass migrations. Scottish people, because the Scots had been revolted against the English crown in 1745 and 46, a mere 30 years before the Revolution. The Scots weren't really looked upon as being part of that established culture until we get in a war with Great Britain in 1776, and we need the Scottish bodies to fight our war. So suddenly the Scottish people are white. And if you watch, you guys may not be old enough, and your parents may not want to watch it, but if you watch Outlander, you'll see that as in that fictional narrative, where the British government in the colonies are beginning to co-opt Scottish immigrants to fill their ranks. So that process continues, and again, as I've said, my father's family came over during the Highland clearances when the British government wanted to depopulate the Scottish Highlands. We went to North Carolina and landed in North Carolina, Wilmington, and then had to move into the Appalachian Mountains because Scots weren't allowed to settle there. They had to keep moving west. The next big mass migration comes in the 1840s and 1850s when the Irish potato famine forces millions of Irish to come to the United States and Canada and other places. And you could not vote if your parents or you had been born in Ireland. It wasn't again until the Civil War when the U.S. government needed Irish bodies to fill the ranks that suddenly they became engaged in the political process. Same things happened with Southern Europeans from Greek and Italy back in the 1870s, 1880s. Same happens with Russians and to a certain extent Jewish populations that came over at the latter part of the 19th century. Ta-Nehisi Coates says that we continue to redefine what constitutes white or what racial groups are politically are allowed political authority or empowerment, and that as we move down the road, these arguments that we're having are about political civil rights, civil liberties, are not going to be less important. They're going to be more important because he feels, and he's written, that we're just going to have more, we'll just change the definition of who's white. And minority status will still be conferred upon, and he's got a lot of historic examples. So Ta-Nehisi Coates sort of sets the context for the discussion we're about to have. So we are going to start with Plessy v. Ferguson in 1896, and you're really going to see Ta-Nehisi Coates' concept of who gets to define race as a key part of this conversation. Homer Plessy was considered, and Plessy v. Ferguson got to the U.S. Supreme Court in 1896. Homer Plessy, by law in Louisiana, was defined as an octoroon. He was a person of 1/8 African ancestry, and Homer Plessy's picture is right there. In Louisiana, they had, were part of the one drop law. If you had a single drop of African ancestry, a single drop of blood from an African ancestor, you were considered black. Homer Plessy was legally considered black, even though only one of his great grandparents was black. So in 1890, Louisiana passes the Separate Car Act. Now, the Separate Car Act required whites and persons of colors to be segregated into segregated train cars. White people could sit in white train cars. People of color could sit in the colored, as they were referred to at the time, train cars. So first of all, let me state clearly and openly, this was a case where business hated segregation. If you're going to do that, train companies, railroad companies have got to buy more train cars. Okay, so they hated the idea. But the law was passed, and immediately afterwards, a group of prominent blacks, Creoles of color, and white Creoles, again, you see that stratification of a completely artificial definition of race. Black Creoles of colors and white Creoles in New Orleans formed the Comité des Citoyens, the Committee of Citizens, and they began looking for a test case. So they found Homer Plessy. And Plessy volunteered. And said on the 7th of June, 1892, Homer Plessy boards a whites-only car. The railroad company was informed in advance of his racial heritage, and that he was legally defined as colored in Louisiana according to the Separate Car Act of 1890. He was in violation of the law, and the railroad company was informed of that. In addition, the Comité des Citoyens had hired private detectives to be on the train, and if no one else would detain Homer Plessy, the private detectives from the committee were going to detain him. The committee was trying to force this to the Supreme Court to overturn the law. So Plessy v. Ferguson goes to the Supreme Court in 1896. Plessy argues he was being denied his rights under the 13th and 14th Amendments. He had been convicted and he had been fined $25. He appeals to the Louisiana Supreme Court and is denied. He appeals to the U.S. Supreme Court and continues to argue his 13th and 14th Amendments are being infringed. First thing the Supreme Court did was throw out the 13th Amendment argument. They say you have no standing on the 13th Amendment. But on the 18th of May, the court returned a 7-1 finding against Plessy, and Justice Henry Billings Brown, you can see here, very, very dour-looking guy, wrote the majority opinion. And what he said was, your rights aren't being infringed because you had an equal rail car to sit on, so you were fine. Okay, you have no standing. You haven't suffered a harm. You could have ridden in the colored cars. You were fine. So what the court says in 1896 is separate but equal is okay, and that formalizes de jure or by the courts or by the jurists segregation. Okay, we have now finished out our triumvirate of bad Supreme Court decisions. We started out with Dred Scott v. Sanford, as a horrible Supreme Court decision that was just clearly stating that a person born in the United States was not a citizen of the United States, based solely on his color, was a horrible decision. In Korematsu versus the United States, we find the second, where Justice Black tries to divine the difference between race and ancestry. And then finally, slightly out of order, we have Plessy v. Ferguson, where the Supreme Court of the United States says that separate but equal stands under the law. Now, how that almost immediately impacts, and again, this is what Justice Brown said. Go to the next slide where it says Plessy v. Ferguson, 1896. The object of the 14th Amendment was undoubtedly to enforce the absolute equality of two races before the law, but in the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality or commingling of the two races upon terms of unsatisfactory to either. We consider the underlying fallacy of the plaintiff's arguments to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this is to be so, it's not by reason of anything found in the Act, but solely because the colored race chooses to put the construct on it. Just reading that, I hope that you're deeply offended by that last statement. We're going to give you separate things, and if you think that's inferior, that's on you. That's not on the white guys. That's on how you engage with it. And again, that opening paragraph, first paragraph I read, that says, this is only supposed to, the 14th Amendment is only supposed to have to deal with the law, not how you engage socially. So it is just really terrible legal thought. Then we come up 3 years later in Cumming v. Richmond County. Now, the Richmond County here that we're talking about is Richmond County, Georgia, just across the river, literally, in some cases maybe yards from where you guys live. In 1880, Richmond County establishes Ware High School, which is, and you'll see this, and I've seen that historic marker. Richmond County establishes Ware High School as the black high school in the county and charges $10 a year tuition. So first of all, they had a white high school in the county, and they did not charge whites tuition. That was paid for out of taxes. But blacks in Richmond County paid it just so they had the opportunity to send their kids to high school. In 1887, a little misprint here, the county commission recommends closing Ware High School and pointed to 4 private schools in Richmond County that the black students could attend. So what they're saying is, hey, listen, we're not going to pay for a black high school anymore. You guys can pay the private tuition to go to the private schools. That to us is fine. After closing Ware High School, the county collected new taxes, $45,000, to improve schools, including the high schools that no blacks were allowed to attend. So several parents of former Ware High School students sued. The leader of the case was the Cummings family. So let's sort of establish what's happening here in Augusta, Georgia, in Richmond County. In 1880, the county opens a black high school. 7 years later, they close the high school. And even though unfairly they're charging tuition for the black students to attend the high school that the white students, theoretically separate but equal, get to go to for free. The county commission recommends closing Ware High School and points to 4 private black schools that the high schools could attend. The high school students could attend, even though they have to pay tuition. Then as soon as they close Ware High Schools, the county government decides they need to collect $45,000 in new taxes to upgrade schools across the county, including Ware High School. So money is being expended to improve high schools that black students are not allowed or prohibited from attending. And so those parents sued. Cummings v. the Richmond County Board of Education gets to the Supreme Court in 1989. The case was argued, and unanimously the court ruled against the parents. And it said, while all admit that the benefit and burdens of public taxation must be shared by citizens without discrimination against any class or on account of their race, the education of the people in schools maintained by state taxation is a matter of belonging to the respective states. In any interference on the part of federal authority with the management of such schools cannot be justified except in the case of a clear and unmistakable disregard of the rights secured by the supreme law of the land. We have here no such case to be determined. So what the Supreme Court says, and they cite Plessy v. Ferguson as separate but equal being okay. And if it wasn't for Plessy v. Ferguson, this would probably reach the triumvirate of bad court cases. What this says here, and this will be case law for 55 years, is that separate but equal in schools is okay. Okay? Separate but equal, and again, it will be 55 years before. And again, remember this case specifically, and be deeply offended by this, I hope. They weren't just saying that we're going to build a separate high school that you could go to. They're saying we're going to collect taxes to pay for a white high school. You will pay those taxes for a school you can't go to, and then you will have to pay tuition to go to a private high school that your students are eligible to attend. Okay? And the courts in Cummings v. Richmond County said, that's fine. We're good with that. You have a high school, and it's not a federal issue. All right? This isn't an issue of law. This doesn't fall under the 14th Amendment because the 14th Amendment really doesn't apply to the states. It applies to the federal government, not the state governments. Okay? All right. So that's where we're going to stop today. We're now going to fast forward. When we come back, we're going to fast forward to 1954. We will start with Brown v. Board of Education. We're going to talk about a murder in Mississippi that really lights the fuse to the civil rights movement of the 1950s and 60s. We're going to look at how the government engaged that. We're going to look at a whole bunch of laws that were passed in the 1960s, which was probably the greatest legal shift in race relations in the United States since the 13th, 14th, and 15th Amendment. We're going to put all that together. Then we're going to sort of wind up civil liberties and civil rights and sort of pull it all together. Okay? All right. The discussion question for the week will come after that. I hope everybody's doing those discussion questions, because that's going to be 100 points of your final grade before we're all done with this. You will get a discussion question sort of wrapping up civil rights and civil liberties. You'll get another question on political parties. Then you'll get another question on elections. Okay? All right. So listen, everybody, stay safe, stay healthy, stay away from each other at least 6 feet. Try not to go out unless you absolutely have to. We will continue to push forward with this class, no matter whether or not we're in school or not. We're going to finish this class together. And I will talk to you in a day or two. All right. Stay safe. Stay healthy.